Hello, I'm Brian Roten, senior reporter at Hotel News Now. I'm joined today by Andria Ryan, labor attorney and partner at Fisher Phillips. She's also the co-chair of the firm's hospitality industry group. Today, we're talking about a new pair of federal regulations that have come out that have had a significant impact on employers. The Department of Labor's decision to increase the salary threshold for overtime exemptions, moving it to $43,888 starting July 1st, and a second increase going to $58,656 on January 1st, 2025, and also the FTC's banning of most non-competes. Andria, welcome and thank you for being here with us today. These are two, major decisions, and both dropped pretty much at the same time. I'm sure that has some employers' head spinning, and in turn, that meant folks like you had your phones ringing off the hook.
Yeah, Brian, it's nice to be here. And you're right, they dropped at the same time. We've been waiting for them. The proposed rules came out and the comment period expired. And so we've been sitting on hold, waiting to see what the Department of Labor and the FTC were going to do. And they finally dropped the rule. Some things we expected, some things we didn't expect. But it's time to prepare, that's for sure.
So let's start with the overtime threshold decision. So we'll go with what's new about it first, and then we'll look into the history of it, because this, as you mentioned, you've been waiting for this, and there's been a lot of back and forth on it. So let's start with the new. What can you tell us about this newest threshold rule from the Department of Labor?
Well, a little bit of a reminder. In order to be exempt from overtime, an employee needs to meet three tests. They need to be paid on a salary basis. They need to be paid the minimum salary as set forth by the Department of Labor, and they need to meet certain duties. So all three have to be met for someone to be exempt from overtime. And the salary level for exempt employees has been, for a very long period of time, $35,568, about $684 a week. Mm-hmm. It is fairly low for exempt positions, and I think we seem to recognize that. The Department of Labor has, as you noted in your opening, has issued new thresholds on a staggered basis on July 1st and then again on January 1st, 2025. In order to maintain exempt status, meaning exempt from overtime, you're going to have to pay employees those new thresholds. One's 44,000-ish, and the other's 59,000-ish. Mm-hmm. So some significant decisions and changes need to be made moving forward. We've seen this challenge. The Obama administration's Department of Labor tried to make some changes, different numbers, different day, and a federal judge joined it almost a few days before it was to go into effect. And the Obama administration seemed to have abandoned the rule. The Trump administration did not take it up, and the Biden administration has, as you can see, taken it up again at the Department of Labor.
The Obama administration tried to raise it to around $48,000 a year, and that was a significant increase from the previous level.
Yeah, or the current level. It's 35,568. Yeah.
So, do you remember what the basis was for enjoining it? Was it like a stay until they could go through it, and then the administration changed and then they dropped it, or I can't remember if it was an actual ruling throwing it out.
No, it was an injunction. Okay. And it was basically mainly, and it's been a while, as you can imagine, 2016, I think, but yeah, mainly on, did they follow the proper administrative procedures, and does the Department of Labor have the authority to make this change? I think we're going to see a similar challenge on this one as well.
So, the Department of Labor went through the entire rulemaking process. Can you kind of walk us through what it is they have to do to make such a change?
Well, the question is I think they followed the proper steps. The question is, okay, is have they overextended their authority? They are required to publish the rule, open it for comment, which they did. They went through all of those steps, and they got a lot of comments from a lot of industries, particularly this one, retail and hospitality. Had some strong objections to the proposed changes. And as I said, what we were surprised about is the proposed rule didn't have this two-tiered approach, this July 1 and January 1 approach. That was not in the proposed rule. So I suspect there could be a challenge based upon that, as well as many other things. I mean, it's a kitchen sink kind of complaint that gets filed against these.
Sure. Yeah. I mean, looking at the the change for July 1st, almost 44,000 a year. That's, I mean, going from 35 to 44, not. I mean, it's kind of a big increase, but at the same time, it's not as much as the Obama administration's attempt years ago. But to have another increase,
January 1.
Yeah,
some companies I'm talking to are really in a pickle because, they inevitably, if they decide to move from 35 to 43, move some of their managers to keep them in overtime exempt status, then they still are facing 6 months down the road another significant bump. And are they willing to do that? So do they want to make these, do they want to make not necessarily the salary change, but knowing that they're going to have to make that big bump again in January, or are they going to change the way they're paying managers or certain managers and make them overtime eligible?
Right. And then that's the thing that they'll have to figure out what they're going to do. It's either increase the pay to keep them exempt or to switch them to hourly.
Hourly, well, you can pay overtime on a salary. It's a little bit harder and a little bit administratively harder, but they're overtime eligible however you pay them.
Gotcha. Okay.
The goal of the Department of Labor here is to have more people, is to increase the number of employees eligible for overtime. That's the direction they want to push most employers. And several outlets are reporting, millions of Americans are going to be overtime eligible that weren't in the past. I don't know where they get their numbers, but statisticians, they do their job well.
So, for employers who are seeing July 1st come up pretty quickly and January 1st, not too much longer after that, what should they be doing right now?
Yeah, that's a great question. It's time to, sort of work through a decision tree. You need to, even though we're expecting legal challenges, if you recall back to 2016, people were either had made the changes, were on the verge of making changes, and the injunction came in, and the injunction was issued. So you've got, between now and July 1st is not a lot of time to start thinking about what those changes are. And so, how much are you going to pay? How are you going to, which managers are you willing to move into the new salary levels at both stages so that they'll remain overtime exempt? If you're going to change them to overtime eligible, they're going to have to track their work time, which they have not been doing if they've been a salaried exempt manager or supervisor. So you've got to train employees and make sure they understand that all of their work, including work done from home and questions answered on the weekends or when they're off, when they're not scheduled, are all hours worked for purposes of overtime tracking. And that's not something they've been doing. And then you need to just determine if benefits will be affected. If you decide to leave somebody or move them to hourly or overtime eligible, are they going to lose sick leave benefits or vacation or other policies where your exempt employees are qualified for those benefits, but your non-exempt employees are? It could be a real morale problem.
That makes sense. And I mean, when you're looking at potentially raising someone's annual pay to, about 44 a year and then up to 58, 59 by the start of next year, is there really much point to kind of stalling it, 43, 44 in the middle of the year if you're just going to have to bump it up again by the start of the new year?
Well, it's budgetary issues, and they didn't give us a whole lot of time, did they, to budget for those kinds of increases?
Yeah, because I mean, companies that are operating now, they set their budgets, the fall of last year. So
that's right.
Budget season, you're going to hit in the fall of this year. So I mean, you can budget for January 1st.
Yep, maybe. Something that I want to also mention, I don't want this to go unsaid, because a lot of times we get this question is, can part of the salary that the DOL is going to require be
Mhm.
made up of any other types of compensation, like non-discretionary bonuses, incentives, commission, for example? And the answer to that is yes, but only 10%.
Okay.
So you cannot, and that's 10%, whether it's weekly, monthly, or annually. You can make up 10% of that minimum salary level. And under the new rule, the salary level will automatically increase every 3 years.
So that's something to bake into your budgets each time then.
It is. It is. This is a good time if you think you've got people that are not in the right position, or they're improperly classified, or they're not performing the duties, or you're concerned that they're not performing the duties to qualify for exempt status. Now, this is the time to take a really hard look and potentially make those changes.
And you had mentioned that the new rule, this will include, reviews and increases over time. Is that how it currently works, or is the current level static?
No, the current level is static, and it's been static for a large number of years. That's why when I started mentioning that the salary level at 35,000 has remained there for quite a few years.
Yeah. I mean, I can see the argument that, as we've seen inflation over the last couple of years, it certainly doesn't hurt to at least have a review of what the threshold is. But I can see how jumping, roughly $10,000 for the increase just for July, that's a big bite to swallow.
Yeah. And it's gonna really affect smaller properties that have limited, a general manager and maybe a couple of other managers, but those managers do a lot of daily hands-on work. In order to really qualify as an executive exempt employee, you've got to the primary duty has to be management. Your primary duty can't be operating, working front desk shifts and a chief engineer, for example, who's turning a wrench all day long. The argument it can be made that management is not their primary duty, and that's why I said it may be time to take a look at some positions the way you've got them classified.
And is there typically a lot of misclassification, at least under the duties test?
Misclassification is the biggest concern with. I mean, wage and hour laws are very complex, and there's tip credit issues and tip pooling issues and calculating the regular rate, but misclassification is a very common problem.
Let's jump on over to the non-competes here. This was a pretty broad rule, as I understand it. It gets rid of non-competes for most employees, and it bans the creation and enforcement of new ones. So can you give us some context here about, what was the purpose of non-competes to start, and how did they work up until this rule came out?
Yeah, what's really interesting about this, Brian, is the feds have really not gotten involved in non-competes. Non-competes are generally enforced and viewed on a state by state, under state case law, because it's a contract. It's an agreement between two people, right? I agree to give you this job, and in exchange, you're going to agree when you leave that you're not going to compete for a limited period of time in a certain area or for certain competitors. So it's an agreement, and so it's really governed by state law, and all the states are different. Well, many of the states are different. So it's important that they've always been important that they be carefully crafted so that they can be enforced where you want them enforced. And some states have banned them. California's banned non-competes. Completely. And
Okay.
I think there's some sale of business exceptions. I'm not a California lawyer, so don't take that to the bank. But and there's some, and in this federal ban as well, there's some exceptions for sales of business as well. But it is the Federal Trade Commission has basically said that this is a non-competes are a restraint on trade, and people, if they can't move from job to job easily, then that puts a restraint on trade. They have to say that because that's the only way they get to issue a rule. If okay. It's got to be within their purview, right? So they said it's within our purview because it restrains trade. And what they did, and we've already seen within 24 hours, there was a lawsuit filed, I think by the U.S. Chamber. So we're going to see some legal challenges, even more than the one that's already pending. But on April 23rd, they did three basically critical things. You can no longer enter into non-compete clauses with workers. So they banned them completely moving forward. Very, very specific, one very specific exemption, but I'll talk about that in a moment.
Sure.
You can't enforce your existing non-competes unless they cover certain senior executives. And that's the one exception that the FTC included in here. So if you have an existing non-compete, you can't enter into any new ones. But if you have an existing non-compete with what's considered a senior executive, then you can enforce it. And a senior executive is someone that earns $151,164 annually, kind of a random number,
okay,
and are in policy-making positions. So you are allowed, if you have that senior executive, you're allowed to enforce a existing non-compete, but not enter into new ones. And the third thing it requires is providing notice, explicit notice to current and former employees that their non-competes are no longer enforceable. So they put quite an administrative burden on employers now to comply with that leg of the stool, and severely restricted the enforcement of any non-competes that are in existence at the moment.
Gotcha.
Now, remember, Brian, because a lot of people use non-competes very broadly.
Yes.
And they mean every kind of restrictive covenant, but the FTC says this only applies to non-competes, and that is an agreement that you won't go to work for a competitor, and however that competitor is defined. It doesn't prohibit non-solicitation of employees, non-solicitation of customers, although the FTC did sort of give themselves a little out, unless it on a case-by-case basis, unless a non-solicitation of customers would effectively be a non-compete.
Gotcha. Okay.
So pretty broad brush.
So I'm, thinking within the boundaries of, hospitality. I mean, for the most part, it would be reasonable to expect to see non-competes among, the executive set within, a company, either, a brand company, an ownership company, or management company. I can't imagine there'd be that many among, property level.
Yeah, frontline staff. Yeah.
So I'm not saying
maybe a general manager. Yeah,
okay.
Maybe a general manager. Certainly sales managers. That's probably where we see most of the restrictive covenants in the hotel and the hospitality industry on the sales side.
And that's where you may see some of that non-solicitation stuff come into play here, right?
Correct.
So, but I mean, we have, this is kind of a reaction to, there have been, broadly, not just in hospitality, but broadly, there are a lot of companies who misuse non-competes, and this is kind of a reaction to that. So this is, I think people were maybe expecting a more tailored or nuanced rule coming out, regarding this, as opposed to just a complete ban.
Yeah, the complete ban is really throwing a lot of folks for a loop, especially in many industries, not just hospitality. There's a lot of industries that rely heavily on non-competes to protect, healthcare, for example. You sell your dental practice, or you sell your medical practice, or you leave it, and they don't want you opening your door, a block down the street and taking all the patients that you just sold your business to. So that sale of business exception, to the extent that it remains in place, is going to be important. But it's really kind of time to take a look if you've got non-competes out there, and get ready to comply with the provisions on rescinding them, or providing notice that they're not going to be enforced. Consider, if you are using non-competes, whether there's some alternatives. Do you need to beef up your confidentiality and trade secret and non-solicitation of customers and those kinds of policies and agreements? It's probably a good time to consider whether alternatives might work for you. The other thing is you always want to do, Brian, is identify what you consider to be confidential and treat it that way. Because it's more important now than ever if you're not going to have any non-compete. So let's say, for example, you've got a chef that creates menus and they're unique to your property. We need to take steps to make sure that people don't take them, leave with them, make copies of them. And it's clear to them that this is our property.
Gotcha. If you got a signature dish, you don't want a hotel restaurant down the street suddenly having the same one.
That's right. And same thing on the sales side, group bookings and contacts and event planners. Those are important contacts that need to be protected.
I mean, in a people-focused business, relationships are everything.
They are.
So you had mentioned that day one there was already a court challenge to this. Is there any information about that you can share if you know about it, or just what are your thoughts in terms of, this is an FTC decision, so if there is a change in administration either this year or in future elections, FTC just a change in the makeup of the voting members there, how long or how long is it to, if they were to reverse course?
Well, that's always a good question once you get to the federal courts. But I mean, not surprisingly, the first lawsuit was filed in Texas. And the goal is no surprise. And the goal is striking down the rule in its entirety, that it is beyond the authority of the FTC to issue. Because remember, the FTC, they don't have unwielding power. They have to prove that non-competes are I'm not sure what the phrase is within their statute, but the statute that they administer is a restraint on trade.
Mm-hmm.
Now, think about this, Brian. We've had non-competes basically unfettered, unless fettered by state law, for many, many years. And I think the argument will be, what's the proof that trade has been restrained? We'll see.
Yeah,
we'll see. So what I'm sure we'll see is an effort to get it at least put on hold, and then scrutinized to try to strike it down.
And just in terms of change of administration, I gotta imagine if it switches at any point, this is potentially something that they would want to reverse course on.
They did it. The Trump administration reversed a lot of Obama executive actions.
So gotta imagine it'd be the same thing here.
And same thing, yeah, and same thing. The Biden administration did the same. So it's the prerogative of the administration, right?
Yep. So not a lot of stability there then for businesses, if things keep changing every 4 or 8 years or
that's
so.
what the courts are for, right? So that's what the courts are for. Hopefully a court will look very carefully at this FTC ruling and say, give us a good firm ruling, yes or no. It's outside of their authority.
Fair point. All right. Well, I think that takes care of everything I had here. But any final thoughts before we close out?
Well, it's a lot at a lot at one time, and I think from a practical perspective, the folks in the industry really need to take a strong look at that overtime rule. You got a lot of folks out there that you're gonna have to make some changes with, in terms of their compensation and their day-to-day work lives. So start thinking about what that looks like and how you're going to communicate it.
All right. Well, Andrea, once again, thank you so much for chatting with us, and thank all of you for listening. Stick with Hotel News Now for further coverage.
Hi, I'm Isaac Colazo, Vice President of Analytics at STR.
Hi, and I'm Jan Freitag, National Director for Hospitality Analytics for the CoStar Group. Tune in to our new show, Tell Me More, a hospitality data podcast.
It's a podcast on the global hotel industry, its current trends, what we're thinking about, and where the industry's going.
And we like to have fun with the data too. Find us on hotelnewsnow.com or wherever you listen to podcasts. Subscribe today.
Thanks for listening. This episode was recorded May 6, 2024, and produced and edited by Brian Roden. Go to hotelnewsnow.com every day for the latest in the hotel industry news.